Indiana constructive possession. There's two types of possession in Indiana: actual possession and constructive possession. This video is solely going to focus on constructive possession. Now, what exactly is constructive possession? So constructive possession is something where the prosecutor or the state of Indiana tries to say, hey, you possessed an item, whether that be drugs, a gun, or something else, but it wasn't on your physical person. Some of the elements that the court look at is going to be, where was it found? In other words, how close was it found to you? Number two, was the item they're looking for, whether it be drugs or guns, is it commingled? Or is it mixed up with other items that were yours? For example, if you're being charged with a gun crime and the gun's found in the back seat, if it's in the back seat and it's in a book bag, is that book bag yours? Do you have other belongings in that book bag? That's what we mean when we talk about commingling of items. Number three, did you have knowledge the item was there? We see this happen a lot in drug cases in houses. I may not necessarily know what's in someone else's room in my house. Presumably I would, because I own the house. The only other people in my house are my wife and my 2-year-old daughter, so generally I have an idea. But in other cases, if you're living with a friend, you're living with a family member on short terms, they may not know what's in your room. So we might be able to make the argument for your family member that they don't possess what's actually in your room because it's your room. So that's another thing the court looks at. There's no A plus B plus C formula for the constructive possession. When it comes down to it, the court weighs these elements, and the court then has to make a determination. Is one stronger than the other? Are all these elements strong? To determine at that point, hey, did this person really possess this item? One of the best examples I can think of is myself and Attorney Benitez. We had a jury trial in Tippecanoe County, and our client and his friend were driving in our client's vehicle, and there was a gun involved. The gun was in the glove box of the vehicle that our client owned. However, evidence and testimony would show our client's friend pulled the gun out of his pocket, put it in the glove box. So if we go back to the element test, my client owned the car. My client knew the gun was there because he saw his friend put it in the glove box. So you've got a couple of the elements pretty strong. Actual knowledge, they own the vehicle. Commingling of other items. Yes, he's got his registration in the glove box, and he may have some other things in the glove box as well. But in this case, a jury found our client did not possess that firearm because evidence, testimony came out that it actually came off of his friend into the glove box. So while in theory you can possess something in your glove box, this is an instance the jury said no. If you or anyone you know have been charged with a crime, especially if it involves constructive possession cases, those are absolutely amazing cases for a defense attorney, and it gives us a lot of great opportunity, either A, to try and negotiate on your behalf, or even take a case to trial. We love trials. If you or anyone you know are charged with a case involving possession, give us a call, 317-632-3642. Remember, always plead the fifth.